Marshall Law is here. Marshall Chriswell joins us in the studio on this program intended for informational purposes only. The information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date, your particular legal problem. Each legal problem depends on its individual facts. Different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Marshall Chriswell certainly fits that description. Good morning.
Good morning.
How are you?
I'm doing well. How are you?
Wonderful. I wanted to talk a little bit more about real estate law. We've been in the last couple of segments talking about real estate law, and you've given some pretty vivid examples of why people should use the services of an attorney in real estate transactions. There are so many different types of real estate transactions, and you can be on the seller's end, the buyer's end. There's going to be something specific to you that is really going to call for the services of someone like you, isn't there?
Yeah, that's right. Every transaction is different, and it's so important to ensure that the right steps are taken prior to the closing, prior to taking ownership of the property, because it's always harder to deal with problems later. Mm-hmm. So, we run into all kinds of things. I was thinking this morning, I was thinking this morning about some of those and some of the things that I've run into over the years that have really that we've been able to resolve, but that would have caused a lot of problems for a buyer down the road. Mm-hmm. For example, access problems. That's one that rears its head quite a bit.
Yeah, you've said that before.
Yeah.
Explain what access problems would mean.
So whether you're in town, or you're out in the country, these issues can come up. In town, it's often say shared driveways, mm-hmm. Or private roads, private alleys. Alleys that were never opened to the public. Mm-hmm. So there is often some gray area about whether the property owners have access rights over those, and even if it's clear that they should, sometimes there are situations where they've been treated as extensions of people's yards or property, and they've been blocked off.
Yeah, somebody can get landlocked.
You can get landlocked, yeah. And out in the country, it happens a lot too. You have private roads and drives that have been maybe used for a period of time to access a particular parcel of real estate, but never put on the record. Mm-hmm. Nothing was ever recorded to indicate that those roads were to permitted access. And without access to your property, even if you have that road and you know that you're going to be able to physically access the property, without legal access, without something on the record to state that you are able to use that to get back there to your property, that you can't get title insurance, you can't get clear title, and you're going to have a heck of a time selling the property down the road if you need to do that.
And obviously all three of those things you just mentioned, that's where an attorney comes in.
That's right. We have to make sure before we get to closing, before the deed is signed, that all of those title issues are taken care of, and legal access is a big one. Another one is incorrect property descriptions. For example, I represented a woman who was selling her family farm. Had been in the family for 50, 60 years, something like that, mm-hmm. and prior to selling, I looked at I did a title search for her and said, there are really some inconsistencies and some ambiguities in some of the calls in the legal descriptions here. As we run into a lot in Indiana County and in this region, we have very, very old legal descriptions, and often there haven't been surveys or things to clarify those for many years. So I said, you might want to have a survey done. And it turned out that the legal description omitted about 10 acres of the property.
Oops.
So it just wasn't in there. And they'd been using it. The family had farmed it for many years, but it wasn't included in the legal description of the property. And it also wasn't included in the legal description of any of the neighbors.
Oh,
it
yeah.
was just out. It had never been
It's a phantom piece of ground.
It was, and we were able to get that fixed. We had to file what's called a quiet title action, give notice to all the neighbors, and present evidence of her family's consistent use of that property for over 21 years, and we were able to get a new deed with a new description that included that for her. But if that would have come up, luckily this was a seller that decided to do her homework beforehand, and we identified the problem. But if it would have come up later, it would have possibly killed a deal because it would have been such a delay.
What about subjects of property disputes between property owners, particularly in the case you just cited, where the survey may have been done 70, 80, 90, 100 years ago or more, and that was the last survey done on the property because nobody ever had a need to. All of a sudden, okay, it's time to break up that property into separate lots. It's time to sell the property. Generations pass on. And, we've always said that our property goes down to that big oak tree down there on the corner.
Right.
And then there's a rock in the woods over there that it's got a white stripe painted on it, and that's the other boundary.
Yeah.
It's not exactly legally precise, is it?
That's right. And sometimes you see those descriptions, you look in the deeds and you actually see in the descriptions that they say, well, beginning at the hickory tree at the northwest corner of the adjacent lot and down to where the old creek runs through, and those things have long gone. So these property boundaries and descriptions, it's important. Here in Pennsylvania, some states you have to have a survey. You sell property, they require you to have a survey just as part of that process. Mm-hmm. Here in Pennsylvania, I don't think there's anywhere that requires that. And but it's a good idea. And you're right. Over time, there are people just kind of their course of conduct. They treat certain property as their own, and they're begin to recognize certain landmarks as boundaries. And, it definitely disputes arise from that. And, I mentioned the 21-year rule just in passing a moment ago. And I think we've talked about that before in this show. It's called adverse possession. Mm-hmm. And if you use property as your own for a period of 21 years or more in Pennsylvania, not with permission of the neighbors, but if you just treat it as your own and maintain it, you can actually gain rights to that. And then what happens when that conflicts with the legal description in the surveys? So those issues all it can get very complex. Yeah. And all of them are cause for, you mentioned a couple of moments ago, the lady did her homework. She was prudent and she wanted to know what she was getting into as she conducted this transaction. First step needs to be an attorney in that process. That's right. The first step for her was, she wanted to make sure that she wasn't going to have a problem when she went to sell this property. She knew that it hadn't been surveyed in a long time. So first thing we just did, like I said, a full title search and had a survey done. We identified those problems and we were able to take care of them in a timely manner. What about those people who say, well, it's always been my piece of property. I've always treated it as my piece of property. If I do something legally with it, I might find out it's not really my piece of property. And my neighbor, I might just awaken my neighbors to the fact that I've been using their ground all this time. Right, and there, as I mentioned, the adverse possession rule does provide some protection for that. Mm-hmm. And that's the purpose of that rule. If you're maintaining a piece of ground, and your neighbors have ceased to maintain that, and you do that for the requisite number of years. You can gain those rights. So, but there is the idea that we don't want to cause a dispute here if we don't need to. Talk to an attorney. Because every case is different. So let's get all the facts on the table, talk about it, and see. Do you have a good case to actually legally encompass this portion into this portion of ground into your property, and then we can take the steps to do that. I would assume where there is a waterway going through a property that there are some legal ramifications there too. Certain uses that there can be done and not done. You can't dam up a piece of water that goes through your property and deny it to the next property owner down the stream. Mm-hmm. And you can't take actions to cause an inordinate amount of water flow to the other property that might cause damage there. Mm-hmm. And those are the problems that we run into more often are, particularly with the rain events that we've had over the past couple of years. I'm getting a lot of calls from folks that are saying, well, there's a stream that goes through, or there's a retaining pond on an adjacent property that's, not containing the flow of water properly, and we're getting flooded out down here. And some of that is just natural causes that you can't, that you can't really pin on anybody as far as blame. But there are instances where, adjacent property owners will do things that causes flooding on another property, and they're liable for that.
Yeah, and in every one of those cases, an attorney should be a part of this, every step.
Right. We've got to take a look at exactly what's happening, and whether that's something that rises to the level that your neighbors should be liable for what's going on at your place.
It's a protection issue.
That's right.
All right. Well, for folks who want to learn more, and maybe, we haven't talked about the differences between residential and commercial, but I'm sure there are a number of rules that will apply to both, but some that might be unique to either one as well, correct?
There are, commercial transactions. There tend to be not as many protections for buyers in commercial transactions. And that's, not even just real estate, all types of transactions. We tend to protect consumers, and in real estate transactions, residential buyers a little bit more. There's a lot more requirements for a seller to disclose issues related to residential properties that they're selling. So, commercial transactions can be they can be a little bit more risky, and again, important to get some legal advice.
All right. So how do we do that?
You can contact me at 724-465-5826. Stop by the Atrium Building in downtown Indiana, or go online to www.westernpalawyer.com.
Thanks, sir.
Thank you.